connecting people, building communities, helping clients to build multi-generational wealth through real estate.
Today, we have the privilege of having Bobby Vakili again with us. Bobby, welcome. How about you tell us this time more about you rather than me talking about you?
Yeah, sure. Thank you. Thank you for having me again, Mitra. It's always a pleasure to be here.
Always.
I operate a boutique firm in Thornhill, Ontario. We specialize in real estate law, private mortgages, business law, and wills and estates. I've been in practice for 13 years, and I'm very grateful that I've been able to grow the firm each and every year since we've opened. Obviously, we're been in a economic downturn right now, and during this challenging economic cycle, we remain committed to delivering results, and we often work with clients to make our services more affordable, offering payment plans or offering discounts where possible. So yeah, it's again pleasure to be here, and happy to answer any questions we have regarding the changes in the market.
Thank you for such a great valuable share, Bobby, talking about how the market is changing and how you are also making adjustments to serve the clients, our mutual clients. And of course, we can talk about more about that and how you are assisting clients that are going sometimes through a very difficult situation nowadays.
Yes.
So today we are going to talk about buyers and sellers coping with the market shift and having questions. One of the questions that we get a lot is buyer's responsibility when they have a firm deal, when they have an offer that is accepted, and they want to know what is really the time frame for the deposit delivery, and what if they pay the deposit and then they change their mind simply and they cannot close the deal.
Yeah.
And the commission, in case of default, if they decide not to close the deal. And at the same time, also, what if, let's say, they cannot close now and after the agreement expires and they decide to work privately with the seller during the holdover period. We are going to cover all these points. So,
Right.
And we talk about first the deposit and the responsibility, the legal responsibility of a buyer when they have a firm deal, when they have an offer that is accepted.
Yeah, so obviously it's all dictated by the terms in the contract, but typically, in Ontario, we're using the standard ORIA forms provided, and in those agreements, it typically says, deposit is due upon acceptance, but the default clause also goes on further to define what upon acceptance means, and they've defined it as within 24 hours. A lot of the, some of the misconception that I receive from realtors and, other clients is, well, if I don't deliver the deposit, I don't really have to close and, there's no real liability. I actually had a case just like this last year where a client had bought a property out in Brantford area at the peak of the market, or, he paid more than what it was worth. And then he had agreed to deliver a $200,000 deposit on a $1.5 million home, which that is unusual as well. It was more than double what is typical. We typically see 5% of deposits, but in this instance, it was a lot more than 5%. And he got, buyer's remorse and never delivered the deposit. So then the seller, obviously pursued him, and he was ultimately sued by the seller. They brought an application seeking the payment of the $200,000 deposit. And, once you sign on that dotted line, as a purchaser, you have an obligation to basically follow through and, deliver on what you've agreed to in the agreement. So in this case, it was to pay $200,000 and to purchase the property for 1.5 million. So he failed to deliver the deposit. Ultimately, we defended, we raised various defenses, and we ultimately settled. And, I think it was a good result because he ended up paying $100,000 in deposit instead of the $200,000. So in this case, it actually worked in his favor because had he paid that $200,000 deposit, it would have been forfeited. Something that is not always known either is, when you pay a deposit and the buyer fails to close and and it's a buyer's default, then your deposit is forfeited almost always. There's very rare circumstances where the deposit would be, the courts would sort of deem that it would be inappropriate to deem it forfeited. And that's when they sort of pay, disproportionately more than compared to the purchase price. For example, if a purchaser agrees to pay 40% of the purchase price as a deposit, in that situation, the courts may be reluctant to, grant forfeiture. But if it's only 5, 10%, even I would say 15, 20%, the courts are going to deem that deposit as forfeiture, and the purchaser may still be, liable for damages as well.
Which makes sense. Meaning that if, let's say, the buyer pays a minimum of 5 to 10, 15, 20%, then most likely the deposit will be forfeited. Is that correct?
Yeah, exactly. The deposit will be forfeited, and the seller would still have a right to sue the purchaser as well. So let's say the seller sells the property for $2 million. There's a $200,000 deposit, but the seller ends up selling the property for $500,000 less because the market changes. And, in this real estate market, we see that happening. We see big swings happen in short periods of time. And that means the seller has still suffered a loss of $300,000, just by not including all these ancillary types of costs as well. So then the seller would have a right to sue the purchaser for that loss of over $300,000 because they only received $200,000 of the deposit. They ended up selling for $500,000 less, so they still suffered a loss of over $300K. So in that situation, the seller would also succeed in suing the purchaser for $300,000. I mean, as long as we're talking in the situation,
the deposit and the loss on the value.
Yeah, exactly. And obviously, the seller does have a duty to mitigate damages, which means they have a duty to try to minimize damages. So that means they have to relist it, try to sell it to the next person for the highest amount. They can't sort of sell it to their friend for substantially less money and then go claim it from that first purchaser. Yeah. They have an obligation to mitigate damages. And so by doing that, if they still suffer a loss at the end of the day, the purchaser is going to be responsible.
How about legal fees? Are legal fees also going to be the responsibility of the buyer for the seller's fee?
Yeah, that's a good question. The rules in Ontario are typically that costs are paid by the losing party. So legal costs are typically paid by the losing party. Maybe not on a full indemnity scale, not 100 cents on the dollar, but and it's all factual as well, and what offers may have been made. But typically, you should expect to receive anywhere between 40 to 70% of your legal costs recovered after a case it goes to court and there's no sort of real settlement and you receive judgment. You will also receive cost as well. The winning party will receive cost as well.
Okay, thank you, Bobby. So we had a scenario, the offer was accepted. The buyer did not. We were representing actually the buyer in a situation, and in this situation, and the buyer had cold feet and did not bring the deposit. And in this situation, usually we have a mutual release signed.
Right.
At least we can release both parties from any obligations.
Right.
The listing agent actually did not care, and the buyer simply disappeared, believe it or not.
Oh.
And so, what would be the consequences when a buyer does not sign a mutual release? When there is an offer accepted but no deposit delivered?
Well, the buyer would be in default, and the seller could pursue the purchaser for damages. So, yeah, in that situation, if I was acting for the seller, I wouldn't recommend signing a mutual release, first of all, because, unless your damages have really crystallized, then there's no point in really signing a mutual release because you may be shortchanging yourself. So as a seller's lawyer in that circumstance, I would be advising them, we're not signing a mutual release. My client's going to make efforts to mitigate damages by relisting the property and selling it to the highest, for the most amount of money, and see what happens. You don't know. It's too early to sign a mutual release when you haven't really assessed all the damages that the seller may suffer.
What if the buyer signs a mutual release? Would that help the buyer, knowing that he literally signed a mutual release and simply delivered to the listing agent, and then at least on one side things are taken care of? Would it really make a difference?
Well, yeah, that's certainly in the buyer's interest in that scenario. I mean, if I was acting for the buyer, then yeah, I would do everything I can to make sure we do get a mutual release signed, because that way there's certainty that the seller cannot come back at a later date and sue the purchaser.
Which makes sense.
Yeah.
Thank you. Very good clarification. We also got that the time frame for deposit delivery varies. Usually on ORIA form, it says 24 hours, but we had scenarios that, when the buyer is overseas, cannot deliver the money deposit within 24 hours, it's been 5 days, within 5 business days, that is negotiable. That is clear. That is something that the buyers and sellers needs to agree upon. Right. So we covered.
Sorry if I just may add something to that. In commercial transactions where the deposits can be much larger, I'm dealing with one right now. A client's buying like a $9 million industrial land. In that situation, deposit is substantial, a few $100,000, and it's whatever the contract obviously says. And in that situation, it was 5 business days. So it's whatever the parties really agree to in the contract, and it's important to have these terms reviewed to make sure that you're not going to obviously create any legal issues for yourself by agreeing to terms that you can't fulfill.
Thank you. That's a great point. When there are big numbers, then definitely there is also more time to come up with a deposit as well.
Yes.
So, Bobby, when we have a firm deal and suddenly buyers changes, his mind or her mind, and what happens with the commission?
Right.
Who's to pay the commission?
Yeah, I mean, I guess there's 2 commissions. The buyer is probably under contract with the buyer's agent, and there's a representation agreement, a buyer's representation agreement. And based on the buyer's representation agreement, the standard forms that I've seen that are typically used in Ontario, those forms say that the commission is still payable. So even if the buyer defaults, the commission is still payable. In that scenario, there would be no commission to the seller's agent because there's no real agreement, but the buyer, because they have an agreement with their own agent, they would be still responsible to pay the commission.
So I know that, typically the buyer will pay the commission to the cooperating agent if the deal does not go through, if the buyer is in default. we actually, on our agreement, we say that commission payable as per MLS or exclusive listing, which I assume is not protecting us if the buyer is in default. Is that correct?
No, in that situation, I still believe that the buyer would have an obligation to pay the commission as well. No, I don't see it enforced typically. We see deals fall apart all the time, but I don't typically see the realtors pursuing the purchasers, but they would be completely within their rights to do it.
Okay. Yeah, we never done it. It's just that something to know what could possibly happen in a scenario like this.
Yes.
Can the listing agent actually, sue the buyer for the commission if the deal does not close and is buyer's default?
In that situation, I don't think so. I mean, they're not in a direct contract with the buyer, and if
Because they have a loss too,
Yeah, they have a loss too, but they obviously have an agreement with the seller, right? And so that agreement and all their rights really arise from the agreement that they have with the seller, not the purchaser, who's being represented by a different agent.
That makes sense. So one last thing that we are noticing, sometimes buyers view the property, wants to make an offer, they hesitate to make an offer or not. And then once the listing is terminated or expired, then they want to make a deal with the seller privately during the holdover period.
Right.
Can you tell us more about the holdover period and what could be possibly happening?
Right. So, the relationship, again, is going to be governed by the listing agreement. And if there is a holdover period, which is, fairly common in my experience, that you see 30, 60 days. So if the seller tries to make a deal with a purchaser that saw the property or is introduced to the property during the original listing period, then the seller would still have an obligation to pay the agent the commission. Now,
even if there hasn't been any offer?
Correct, yes.
Right.
Even if there hasn't been an offer, if that purchaser saw the property during the listing period or was introduced to the property during the listing period, so it's quite broad, even introduced, which is quite broad language, the seller would still have an obligation to pay the agent's commission. Now, if they list with another agent during the holdover period, then the commission would be reduced by whatever amount they've agreed to pay the new agent.
Meaning that if the buyer comes and purchases the property through the second listing agent, then the commission would be split between the previous listing agent, and the second?
No, so let's say the new listing agent is also charging 2% and the first agent was also charging 2%, then there would be no commission payable to the previous agent because he's paying 2% to the new one. But let's say the new agent is only charging 1.5% and the previous agent was charging 2%, then you would still be responsible for 0.5 percentage to the previous agent.
Yeah. I actually had a scenario where it was a different scenario in this case. The agent made an offer, a buyer made an offer on a property to the previous listing agent. And then we got the listing. And once we got the listing, the buyer made an offer. And the cooperating agent claimed that, it was the same buyer and we just simply wanted to make people happy. The buyer actually came to us the second time.
Right.
And then the cooperating agent who made an offer for the that property through the previous listing agent came forward that, they made an offer before, they couldn't go anywhere. So we literally split the commission to make peace, literally.
Right, I see.
Yeah.
I mean, that's a difference. I think that's obviously dictated by the buyer representation agreement. So whatever
Yeah.
terms were as part of the buyer representation agreement is what would, sort of regulate that relationship.
It is actually a very interesting point. The buyer had a buyer agency agreement with us,
Right.
but he didn't have the buyer agency agreement with the previous agent who submitted even an offer
Oh,
on the property before.
right.
And he was simply claiming that he was showing properties and he submitted an offer, but without even buyer agency agreement.
Yeah.
But, we just wanted to make peace. That was really the very, very complicated situation.
Right.
That we could have simply said no at the time, I do remember, because we really had it right. But he also worked, the cooperating agent worked with that buyer before.
Yeah, sometimes in business, you make business decisions to do what's right. Your legal rights may be more than what that business decision ultimately is. But yeah, there's obviously a distinction in business. What you want to do to sort of make peace or sort of maintain your relationships, and legally you may have greater rights that you're simply not exercising.
True. Thank you, Bobby. Great answers. And definitely, I am sure our listeners would see a lot of value for that. In this market, with the market shift that we see, more and more people are concerned with their mortgage payments, their arrears, late payments. So let's talk about this. What are the consequences of late payments?
Yeah, I mean, you should expect to receive a default notice when you don't pay your mortgage on time. We actually sent out 2 this past week. I represent a lot of private lenders, and these mortgages are maturing. We've reached extensions on a couple of occasions with the other side, and then it was extended to a new maturity date. And again, on the new maturity date, they again default. So yeah, in that situation, you should expect the lender to, send you a default notice, whereby you are typically, given 1 to 2 weeks to sort of pay the outstanding arrears and bring the mortgage into good standing. And if they don't do that, within that 1 to 2 week period, then most lenders will typically start mortgage enforcement at that point. And depending on the terms of the contract and the standard charge terms in the mortgage, again, the lender is obligated to provide anywhere between 35 to 45 days notice before they actually commence formal mortgage enforcement. So at that point, a notice of sale would go out outlining all the amounts due under the mortgage. And if it's not paid within 35 to 45 days, depending on the standard charge terms, they would, start power of sale proceedings.
So within a week or 2 is a notice time. If, let's say, is not paid, the mortgage is not paid within a week or 2, then you send the notice as a lender. And then after that, if the payments have not been, paid, then within 35 to 40 days, then the mortgage payment would be reinforced. And then the lender in this scenario can bring the property to the market as power of sale. Is that right?
Correct, yeah. And if it's an institutional lender, I think that first notice of default will probably give you a little more time, more than the 1 to 2 weeks. But, with private lenders, it's typically, 1 to 2 week default notice. You have an opportunity to cure the default. But if you don't cure the default within that, time period, then, you should expect that the lender to get more aggressive and issue you a notice of sale.
So with financial institutions, A lending, B lending, what's the timeline?
I've seen anywhere between 30 to 60 days.
For the notice?
Yeah, for the notice. and from there, they again, sometimes they're open to negotiation. So if you are, like we've done that in the past as well with our lender clients, where we do try to negotiate with the other side, um, providing them with more time to pay. Sometimes in exchange for that, the interest rate may increase. Obviously, everyone has seen interest rate increase since last year. So when these private mortgages were basically, we did the underwriting for it last year, the rates were much lower than what they are today. So in order to grant an extension, typically in this climate, the interest rate would increase. And that's some kind of concession where, is provided to the borrower, where he gets an extension, but at the same time, we're going to bring up the interest rate to what aligns with current market rates.
Mm-hmm. Yeah. Do you see that there will be more default happening, Bobby, based on your experience with the current?
Yeah, I mean, I do anticipate more defaults for, I would say, the next, 6 to 12 months. All these interest rate hikes that we've seen during the past year, it takes time for them to see the effects of it.
Yeah.
I think we're just starting to see the effects of it. And when clients and borrowers go to refinance because their mortgage has matured, and they realize that, I actually, in some occasions, owe more money now than what I did when I first got the mortgage, or that my payments are now like double, triple. We can see a whole influx of, properties coming to market at that point because they can't maintain the property. Or, some people, and I have borrowers in this situation too, where they think they can just, bury their head in the sand and think the problem's going to go away. And it doesn't. In that situation, I tell my borrowers, like, if you really can't afford it, put your market for sale immediately. It's much better for you to sell the property under your own control rather than allowing the mortgage to get to a stage where the mortgagee comes in, the lender comes in and sells it under power of sale. You want control of the process. So do it now before it gets to that stage.
Very good point, actually. I have seen sometimes listings being on a market under two different names, the seller and also the lender, the financial institution,
Right.
as power of sale. So if, let's say, an offer comes first through the financial institution, would the borrower have a recourse, say, no, I'm on a market and I want to have a better price?
No, I mean, if all the notices have been properly filed and served on the borrower, and the lender is now in possession of the property, the borrower could, I guess, theoretically still redeem the mortgage. They have an opportunity to redeem the mortgage up until there's an agreement signed. As soon as the lender has signed an agreement with somebody else, your rights of redemption are now extinguished.
Yeah. So meaning that if there is an offer and before the offer is accepted, the borrower redeems, make the payments, then the problem is solved.
Exactly, yeah. So before the lender signs an agreement with a new purchaser, he comes up with the money and is able to pay the mortgage in full. At that point, then he's redeemed and, he saved himself from that sort of power of sale situation.
It is a very complicated situation. Not only the payments have gone up, the value of properties have gone down. We've seen scenarios where, let's say, the seller has to sell the property at the price that he purchased without even counting all the fees, land transfer fee, commission. So they are actually losing a lot of money. And how likely the lender would make a proposal, restructure the payments in a way that somehow the borrower would have time to just go through the whole process of what we are going through right now.
Right. I mean, the likelihood is low. I mean, I rarely sort of see situations where the lender and borrower can work something out when it's got to that point. When it gets to the default phase and you're not really making good on your word and making payments in accordance with the terms of the mortgage, it becomes difficult. Although I do have one client who loaned a large sum of money on a commercial property. The mortgage has been in default, since last year. The borrower has been making some payments, and we reached some forbearance agreements. And so there are, it really depends on the lender and whether they believe, I guess, the security is secure. If they have the sense that, it's just going to get worse and there's not enough equity in the property, they're probably going to enforce sooner rather than later. But if they believe there's enough equity in the property and, the borrower just needs a little more time to get his affairs in order, and that, maybe he's selling another property to bring this mortgage into good standing, that on occasion does, sort of work, and, agreements are reached. So it really depends. It's hard to say. I can't say, with any reasonable certainty what percentage of lenders would be prepared to do that. My clients have done it. My clients have done it in the past.
Yeah, it's understandable. Meaning it depends really of the quality of the borrower, how much debt actually they carry on
Yes.
beside the current mortgage. For sure, it makes sense.
And the other thing I've noticed, which is sometimes, we had this maybe 2-3 months ago, where I was representing a seller, and they purchased the property a year earlier, and he had 3 mortgages on title. And when he came to sell the property, the purchase price wouldn't cover the mortgages. So, in that situation, again, we had to try to negotiate with the lenders. There were 3 different lenders, and the third lender actually, had to take a hit. And, in that scenario, it probably makes sense for them to do it, to be honest, because the alternative is worse. The alternative of allowing it to remain in default means that the third lender is just going to continue to be will continue to suffer a loss, because each of those other lenders who will have priority over the third, their default fees are going to continue to increase. Their legal fees are going to continue to increase. That means there's just going to be less money available for the third. So in that situation, if you're being practical and pragmatic about it, the third mortgagee is going to say, yeah, I should just agree and take a little less money right now, because the alternative is worse.
Can of course, the first mortgagee would be paid in total, and then second mortgagee and the third mortgagee. So if third mortgagee is not getting paid in total, can he sue against the loss, or make that they can make a settlement for the difference to be paid over a certain period of time?
Yes, certainly the mortgagee could pursue the borrower for any losses they suffer. Obviously, they advanced a certain amount of money under the mortgage. And if the mortgage has been in default and now there's all these additional arrears as well, and once they sell the property, they don't recover the entire loan, including all the arrears, the mortgagee, the lender, would certainly have the right to sue the borrower in that situation.
So what would be the typical cost actually associated to the mortgage reinforcement, Bobby?
Yeah, I mean, it really depends on the circumstances, but lawyers in this area of law typically charge hourly. And so, hourly rates of lawyers, can fluctuate anywhere from $300 to $1,000 an hour. But, I typically see, to get to that stage where, and it depends, again, if the property is vacant or not, because if it's vacant, it's much easier. You can just go in and change the locks. But if the property is occupied, then you have to go to court and get rid of possession. And so you have to, file material in court and get a judgment. So that obviously is more time consuming, and more legal costs are involved. But let's say if it's going to court, I would say anywhere between, if it's straightforward, it's going to cost anywhere $10,000 to $20,000 in legal costs.
Mm-hmm. Per mortgagee.
Yeah, per lender who has to go through that process and go to court and get a actual judgment. But again, it's all very fact specific. Like I said, lawyers will charge hourly on litigation files.
Yeah.
So
that's beside also the loss in value and costs associated to the late payments, because every time that you're late in payments, then they are going to charge you extra.
Yeah,
right?
there's the default notices, there's going to be administrative default fees, there's going to be legal fees. So that's why I say if you really can't afford your mortgage, it's better to sell now and have control over the process, because all the fees that the lenders and the lawyers are going to add are going to just leave you with less money at the end of the day, leave the borrower with less money.
So, Bobby, I'm sure that you are seeing a lot of scenarios like this. Borrowers who are struggling with their mortgage payments. I have had a client actually that, let's say, the payment doubled, and they had a choice of, let's say, between $2,200 to $2,700 the month before. By the time of renewal, then they said, no, sorry, you have to pay $2,700. You cannot be qualified just to pay interest on a variable rate. They wanted to make sure that they would pay not only towards the interest, but also towards principal because of the high ratio mortgage they had. So is there any possibility when it's upon renewal somehow to negotiate interest-only payment on a variable rate case? Have you seen any scenarios with any banks that you know of that borrowers would have a better chance getting better rate for the time being?
No, I haven't seen that, and I haven't heard that from my clients. And I don't think an institutional lender would agree to an interest-only sort of arrangement on the outstanding principal. I know some banks have done that currently when they're still under contract and the mortgage hasn't matured yet. But I don't really see the bank doing that at maturity stage and say, oh, okay, well, we can just continue on this path where you're only paying interest. A lot of the big five banks, what they do is once the mortgage hits the trigger rate, then they increase your payments.
Yeah.
But before...
Not all banks.
No, yeah, not all banks. Scotia's not doing that, and I don't. But I think the other big four banks, CIBC, RBC, TD, they're doing that. But yeah, so once it hits that trigger rate, then your payments increase. But before that, they just continue to extend the amortization period, or they just continue to apply payments more towards interest rather than principal.
Thank you. Great conversation about concerns that it's impacting actually all of us.
Yeah.
So, Bobby, we talked about buyers. We talked about what could be potential concern for them or questions they might have with respect to the mortgage payment or the purchase payments. Now let's focus on the seller. So when seller actually have a firm deal, and I have had a case like this as well, when they have a firm deal and they decide not to close, right, what would be the consequences in a situation like that?
Yeah,
the buyer.
In that situation, it's a little trickier, to be honest, because establishing damages for the buyer is more challenging. It's still possible, but it's definitely more challenging than the reverse situation when the buyer defaults. But if the seller defaults, the buyer would be entitled to damages so long as they can prove it. The other thing they may be entitled to is specific performance. And, specific performance simply means that they can ask the court to force the seller to sell the property to them because they were under contract. Now, that remedy is not very common for various policy reasons. You do have to demonstrate that the property is unique and there's no real sort of other property that is similar to that property, and that's why you want specific performance rather than damages. But yeah, it's not as common as courts ordering damages because it's much easier for a court to really order damages than specific performance.
Yeah, thank you. I had a scenario actually that we participated. I was representing the buyer in this case, and we actually made an offer on a multiple bid, over asking. The seller was very emotional. Offer was accepted, deposit was given, and then right before closing, he said he doesn't want to close the deal.
Mm-hmm.
And he was very emotional about his condo, and back and forth, back and forth. We literally signed an agreement that the buyer would release. There was a very nice mutual client of ours.
Right.
And the buyer said, I don't want to really close the deal when the seller is not happy. But then I added a clause to make sure that if the seller decides to sell, then he would sell to my buyer.
I see.
And 6 months later, he definitely wanted to sell, and then our buyer bought.
Oh, I see. Okay.
Yeah. So we could have, in this scenario, the listing agent also was not in good terms with the seller anymore because, the seller was thinking that he didn't get the best price. And what could happen to the listing agent commission when the seller decides not to close the deal?
Yeah, again, your rights as the listing agent would be, dictated by the listing agreement, and the standard listing agreements that are typically used, in Ontario, the OREA forms. They typically say again that the commission is still payable. So if in that situation, again, because it's the seller who's defaulting and the seller has a relationship and is under contract with the listing agent could legally enforce that contract and seek the commission.
I know that we could have also, our broker of record was saying that we are entitled to our commission as cooperating agent. Right. But because I was representing the buyer and we really wanted to make sure that, there will be peace again, and not our buyer was not interested in moving it to a property with an unhappy seller. And we knew that we are going to sell another unit to our buyer anyway. But our record was saying that we could be also entitled to the commission no matter what. Is that right?
Yeah, I understand what, because the listing agreement includes a provision regarding the cooperating fee that's payable to the cooperating agent. So if the listing agent does enforce it, then yeah, you would certainly be entitled to the cooperating agent fee as well. But I don't think without the listing agent's cooperation, because they're the ones who have a direct contract with the seller, they are the ones who would have to actually take steps to enforce the agreement. And by doing so, then you guys would, the buyer's agent would also receive their commission.
Okay.
But the process would be under control by the seller's agent.
Okay, excellent. Thank you. Great points for that, Bobby. Now, with sellers, sometimes, again, you mentioned it early, there are several mortgages, and by the time that the seller have to pay all those mortgages, there is nothing left for the commission. How a listing agent can actually be informed of that before even listing a property? to have simply clarity whether they would get paid after making so much effort to sell the property.
Right. Yeah, good question. I mean, I think the only way to really know is to do a title search. I mean, you could obviously ask your seller client how many mortgages he has and whether he believes, that the purchase price at X value is sufficient to discharge all the mortgages. But if for some reason you don't believe the seller is being, candid and, open with you, then you have to do a title search. But I believe Purview also provides this information as well. It tells you the registered charges. So either you need to do a title search, or I think you can access Purview, and and Purview is typically what I think realtors have access to.
Okay, thank you. I mean, in a lot of cases, some sellers are very discreet. They don't want to talk about all their financial obligations, or they can be either under stress, under frustration and all that, and say that, okay, it's not our business. But at the end, it is our business, because we are putting the property on the market, and we want to make sure that we also get paid after working hard on promoting, marketing, and spending a lot of time, energy, and money on the property. So if there are mortgages to be paid, then what's the order where the commission stands based on first, second, third mortgage, and then commission? What is the order?
Yeah, in that situation, I mean, the mortgages have to be discharged, because the sale is not going to happen without the mortgages being discharged. So I wouldn't think that the commission would, sort of have priority over the mortgages. There's clauses within the agreement of purchase and sale. I think it's clause 10, that speak to the mortgages that have to be discharged, and that you have to deliver, obviously, clear title to the purchaser. So without the mortgages being discharged, the transaction is not happening.
Mm-hmm. Okay. And then what's the recourse of the listing agent if he is not paid? Is there any recourse for that?
Yeah, obviously the listing agent has a contract, and they can, sue on the contract. They would have a right to sue.
Okay. Yeah. Thank you, Bobby. Great topic, actually, to talk about also the sellers and the sellers' obligations with respect to the mortgage should be covered in details. If, let's say, the seller cannot pay the mortgage payment, I mean, the homeowner, what could be the consequences? Is there anything else that you think we need to know that we did not discuss with respect to this topic?
No, I think, we covered everything. No, I don't have anything further to add at this point.
Okay, beautiful. Now, let's talk about a few points about tax implications for Airbnb sellers, buyers. Can we go more in details? Talk about the Airbnb hosts, and what are the tax implications of renting property on Airbnb, both for the host and the guest.
Right. Yeah. So I actually just had a colleague argue this issue at the federal court in Ottawa earlier this week. And he's a tax lawyer, and he does tax litigation. So the issue actually hasn't been really decided. So it's unknown. But the government's position is that because this is not a standard sort of rental, you're not leasing it on a monthly basis, you're leasing it on short-term basis, that you actually, when you sell a property of that nature, you have to collect HST on the sale as well. So that's a whole nother tax implication that sellers need to be aware of, that they may attract HST. And so you have to collect HST from the purchaser so you can remit HST to the CRA. And obviously there's capital gains tax and those types of tax implications as well. But the unknown sort of issue right now, I guess, is this the HST implication.
But right now, with Airbnb, there is no HSC. Is that right?
Well, when you do rent to someone on Airbnb, you are collecting HST from each individual party who actually leases from you. So there are tax implications.
When we sell it, then those HST that we collected needs to be paid. That is what you mean?
Yeah, exactly. I mean, you would have to charge HST to the purchaser, and if you have any input tax credits, you can offset it against that. But this area of the law, again, when I was speaking to a colleague of mine who was just litigating this issue, it's unclear right now. It's not settled. It's not a settled area of the law.
Yeah. I mean, look, they cannot double tax. I mean, you are actually, if you are doing it through your accounting, then you collect tax and also you declare, then why would you do that when you sell? It's done once.
Right. Yeah. Yeah. It's a country of taxes here.
I know, especially
introducing more and more taxes.
We are going to see more. Sure.
Land transfer tax in Toronto is increasing as well as of January 1st. So yeah, it's just more and more taxes we hear like every day.
So, Bobby, with respect to selling the primary residence, if a family member lives in a property, how can we actually avoid paying capital gain when, let's say, I'm a parent, I'm a mom, and purchasing a property under my name, and my son wants to live there, not rented, then what's going to happen? Am I going to pay capital gain when I decide to sell? Do you know the answer for that?
Yeah, I mean, everyone is entitled to one primary residence. So if you have a second property that you sell, you should expect to pay capital gains on it.
Even if a family member lives there and I'm not collecting rent?
Yeah, I believe that would be the case, correct.
Mm-hmm. Yeah, interesting. And with respect to that, for buyers, when does capital gain, would capital gain apply at all for buyers?
No. I mean, the buyer wouldn't pay any tax at the time of purchase other than land transfer tax.
Let's say if, for example, my son wants to purchase a property that is under my name,
right.
Just a matter of perhaps arrangement between the family members that I can see. Is that correct? Let's say the family member lives on a property rent-free, and now is time to sell the property. Then the capital gain would be perhaps taken over by the buyer, who can be a family member, but it's just really a matter of arrangement among the family members. Am I correct?
Yeah, I mean, that's getting complex tax questions. I think you'd be best to speak to an accountant. I can speak to the land transfer tax implications, but the capital gains tax and all those, I mean, that's really, I think, best addressed by an accountant.
Okay.
But, to avoid land transfer tax, if the property is mortgage free, then you can transfer the property to your son as a gift, and there would be no land transfer tax.
Uh-huh. Got it. So, meaning as a $0.
Yeah, that's when you typically see
there will be no transfer tax.
Exactly. That's typically when you see properties being transferred for $2. It's because they're transferring it either for love and affection, or it's a gift to a child. And that's when you typically see that scenario, and then it's done without any land transfer tax implications.
And is that only one property? If I have a few properties, for example, can all the properties be transferred for $2 consideration?
Yes.
Oh, that's great. That's good to know.
Yeah. And transfers between spouses either, it doesn't trigger land transfer tax either.
If you want to remove a name, you mean?
Yeah, remove a name, or add a name. If it's your spouse, then yeah, there's no land transfer tax.
Okay, beautiful.
Yeah.
Bobby, thank you for your time today. It was definitely great hot topics, very, very related to the current market shift.
Yes.
Things that everyone is experiencing, whether you are buyer or seller in this market.
Exactly.
Thank you for your time. Thank you for sharing your knowledge with us, and see you next time.
Yes. Thank you, Mitra. Great seeing you. Right.
Great seeing you as well.
Bye-bye.
Connecting people, building communities, helping clients to build multi-generational wealth through real estate.